Thank you for joining this presentation this afternoon. I hope everyone can see the slides and can hear me okay, but if you do have any technical problems, if you can't see the slides or you can't hear me or I'm too loud, then please let us know via the chat box and we'll look into that for you. So this is the business immigration update with QCS and Napthens. My name's Angela Barnes and I'm an immigration specialist here at Napthens, and I'm joined by my colleague Roxanne Buckley, who'll probably give you a wave, who is also an immigration specialist here at Napthens. So welcome to this afternoon's session. We're aiming for it to last about an hour in total, so probably talking for it was presenting for about 45 minutes, and then we'll allow some time for questions at the end. Now, I do like these sessions to be as interactive as possible, but I am conscious that it's quite a big group on today's call. So perhaps if you've got a question, please feel free to ask it, but maybe do it via the chat box, and then hopefully Roxanne or I can come back to you either in the chat or live on the presentation. If we aren't able to get around to your question, then there will be my email details at the end, or hopefully we'll be collating a list of the questions that we haven't got around to, and we will come back to you as best we can with those. Now, so as I say, the session, we're hoping it to last about an hour. In terms of agenda, just for some reason my slides aren't moving on. Let me just have a look into that. Oh, here we go, they've moved now. So in terms of the agenda for today, and it is going to be a jam-packed session because we're pretty much covering everything that is business immigration. So we're going to move swiftly from one topic to the next. So firstly, we're going to look at what changes have been made to the immigration system, particularly over the past year or so, because let's remember that we've been through quite a lot over the last couple of years with Brexit and COVID and everything else that's been going on. So we're going to just do a quick summary of what's happened and what those changes are. So that's in the blue box at the top. Let's look in detail at the changes and how that impacts upon what you're doing in terms of right to work checks or sponsoring migrant workers. I'm going to briefly look at what is the EU settlement scheme. So I'm sure this is a term that a lot of you now will be familiar with, but we're just going to delve into that and as I say, look at the knock-on effect or the implications of the EU settlement scheme for you carrying out your roles in your organisations. I'm then going to pass to Roxanne, who's going to look at the checks that you should be carrying out, so right to work checks, and we're going to look at electronic checks and manual checks, which are now the two options available to you. So we'll look at those in a bit more detail. And then I'm going to look at frontier workers, not something I always cover off in immigration slides, but particularly in your sector, we're seeing more and more frontier workers. So you might see frontier worker permits and people presenting those as evidence of right to work. So we're going to touch on those as well. Then we wouldn't be lawyers if we didn't talk about what happens if it goes wrong and you don't do the checks, or you don't do them properly, or you employ someone unlawfully. So why are you doing the checks? What are the sanctions? What are the ramifications of that? Will be the next couple of slides that Roxanne will help out with. And then finally, we're going to look at the process of applying for a sponsor license, so that you can sponsor skilled workers to come into the UK and work for you. Now, this might be something that you're already doing. It might be something that you're thinking of doing. It might be something that you've looked at and discounted, but I'm just going to give a quick overview of how that may be of benefit to your organisation, so that if you decide to do it, you know broadly what the process is and what the cost may be if you decide to go down that route. And then, as I've said, at the end, we'll have a look at some questions as well. Okay, so first off, why have there been changes to the immigration system? And it's a real potted history of how we've ended up at this point. But would you believe it was back on the 23rd of June 2016, so more than 5 years ago now, when the UK voted to leave the EU. And then that set this process off for leaving the EU, because it obviously wasn't straightforward, particularly in respect of the free movement of workers and individuals from Europe to the UK. So that, as I say, that began a process that took a very long time. But in terms of key dates, so 31st of December 2020, that's when free movement of EU nationals into the UK officially ended. But actually, because we then entered into a grace period on the 1st of January 2021, where most of the aspects of free movement were retained, to allow EU settlement scheme applications to be made. So basically it was to protect the rights of EU citizens who were already resident in the UK at that point. So the grace period came into effect. And then moving forward to the 1st of July 2021, that's your next key date, because this was the point where from this point onwards, EU citizens and their family members would require immigration status in the UK in the same way that other foreign nationals have needed for some time now. So that really was the cutoff. There are certain exemptions, but that really was the cutoff for an EU worker, for example, presenting a passport or a national ID card as evidence of their right to work. And throughout this session, just a quick note, I will be referring to EU citizens, but just so you're aware, when you're doing document checks, etc., EU would include EEA nationals as well, which is those from Norway, Iceland and Liechtenstein, and also Swiss nationals as well. So when I talk about EU workers, I'm including the full group there within my commentary. Okay, so if we just quickly move on to look at the main changes, because as I say, a lot has happened, particularly over the last 6 months and a year. So fundamental changes to the way in which EU citizens can prove their right to work from the 1st of July 2020 onwards. And this is why for right to work checks, it's particularly important that you're aware of the changes, because as I said earlier, you can no longer accept a passport or national ID card as a standalone document to prove an EU citizen's right to work in the UK. So that's why we're giving this presentation today primarily. And in order to implement those changes, the government issues a revised List A and List B document checklist. So I hope that when you're doing document checking, if that is your role for your organisations, that you're familiar with List A and List B. I'd be happy to circulate it afterwards, but a quick Google search will bring the gov.uk's List A and List B. And that's the list that you should be using and always have by your side when you're checking right to work documents. And there were obviously changes that had to be made to reflect the fact that EU citizens could no longer simply present a passport or national ID card. And there were other changes in there as well, which we will look at in more detail. And at the same time, the government issued new guidance in terms of retrospective checks, how to deal with pending or late EU settlement scheme applications, and also COVID adjusted checks. And all of this was covered off because the government preempted that these would be issues currently, especially with the COVID-19 adjusted checks. And we're going to look at each of those in more detail as some kind of tricky issues to watch out for when you're doing right to work checks at the moment. Okay. So I said earlier that we would touch on the EU settlement scheme, and for those of you who I'm sure are already familiar with it, but for those who are not, really the last bullet point on that slide there, it said it aims to secure and document the legal status of EU citizens already living in the UK. So it was to protect those people who were already here and working, so that their rights, they would be able to evidence their rights going forward. And the settlement scheme opened for applications on the 29th of March 2019, and it closed on the 30th of June 2021. So there was a good period of time there where individuals could submit their applications. And the EU citizens can apply if they or their family members were living in the UK by the 31st of December 2020. And there's, in terms of residency, there's certain tests that they need to apply in order to decide if they were living in the UK by the 31st of December. But broadly, if they were successful with their application, they would be granted either settled or pre-settled status. And if they have been living here continuously for 5 years or more, they would typically be granted settled status. But if it's less than 5 years, they would be granted pre-settled status. Now, the important point for you to note in terms of what does that mean for employees who may have settled or pre-settled status, well, they can continue to work for you regardless of whether they have settled or pre-settled status, as long as they've got one or the other. And the important point again, when you're doing checks on these individuals, if they have pre-settled status, you will have to do repeat checks because that is a limited right to be in the country. And so hopefully they will go on to then gain settled status when they get their 5 years of continuous residency, but you will need to check that again in the future. Okay. So moving on to the next slide, how do you check if an EU national has been granted settled or pre-settled status under the settlement scheme? And for this next part of the presentation, I'm going to pass to Roxanne, who's going to guide you through that.
Thanks, Angela. Okay, so I think I moved swiftly on to the next one, so like my little border for my next slide. Okay, so from the 1st of July, as we've discussed, EU citizens and family members, they do require immigration status in the UK. So free movement of EU nationals is no longer a thing. I'm slightly sad at that. The big part of my uni days were on the Van Gend and Lewes, and the free movement of goods and people around the EU, that is no longer a thing anymore. So they will be required to prove their right to work in the same way as other foreign nationals have been. They can no longer rely on an EU passport or a national ID card to prove their right to work. So we might ask the question, okay, well, what's the point in all these checks? Why do we need to prevent illegal working? So there is a legal duty on employers to prevent illegal working in the UK. It is unlawful to employ someone who does not have the right to reside and the appropriate right to work in the UK, or who is working in breach of any conditions of stay which they currently have. Key legislation throughout all of this is the Immigration Act 2016. The employer must carry out right to work checks in accordance with the guidance and any codes of practice. Also conduct any follow-up checks on employees who have time limited permission to live and work in the UK, and also keep records of those checks. So I have seen cases where, you know, with all best intentions, employees have done the first two steps, but then just not done an adequate record that they've actually conducted that check. So we don't want to be falling down at the final hurdle either. Okay, the implications of this if we don't do it is that there are hefty penalties, and we will come back to those later on in this session. So how to avoid that, otherwise known as establishing a statutory excuse. Employers can establish that if they undertake specified right to work checks and retain records to prove that those checks were conducted correctly. 3 key words here for me is obtain, check and copy, and checks must be carried out in respect of all prospective employees before the employment actually begins. I've seen cases where this has been conducted after. You wouldn't be able to establish a defence to any penalty which might be imposed thereafter. So there are 2 types of right to work checks, and there is a manual document based check and an online check. So we're going to focus on the online check, the 3-stage test here. It's just important to note as well on an online check that not all employees or prospective employees will have a status, an immigration status that can actually be checked online. Equally, from the 1st of July this year, there will be some individuals who are only provided with their immigration status digitally, so such as an e-visa, and as such only an online service can actually be used to prove their right to work. So in terms of conducting a right to work check, we have what's known as a share code in order to do that. So we need that share code provided from the prospective employee, and we need this along with their date of birth to be able to do that. And as outlined here on the slide, this is where we will go in terms of accessing that particular service. Please don't share codes themselves. It's a reference number. They are specific and they remain valid for 30 days from the point that it's been issued to the job applicant. And if a share code has actually expired, or the individual has used the code generated by another service, so for example, you can get a share code in respect of right to rent applications, you must ask them to resend you a new right to work share code for you to use to check online. You access the service via the view a job applicant's right to work details. That's the employer section. Now, just bear in mind there are 2 sections, there's a migrant section and an employer section. You need to access the service via the employer section in order to establish that statutory excuse. If you do it via the migrant side and you do your checks on the migrant side, you will not establish that excuse and you still may be liable to a penalty. So as you can see, the Home Office like to throw little obstacles in our way to trip us up. Just make sure you're in the know. The Home Office has an audit record of online checks conducted by employers using the service. Again, just bear in mind you will not establish that excuse if you're not going through the right portal. In terms of actually conducting that check when you've logged into the system, I would say to do that in the presence of the individual. So that's either in person or via a live video link, and check that the photograph on the online right to work check is actually of the individual presenting themselves for work. Okay. Could we have the next slide, please?
Sorry, there we go.
Okay, so what if an electronic check isn't actually possible to undertake? So I'd possibly say the first step, just a certain reason why. So if an individual does not wish, but you just need to bear in mind that if an individual doesn't wish to demonstrate the right to work using the online service, even if they have a status or a document which would allow you to do this online, then you should conduct the manual right to work check. You can't force someone to conduct a check online. You may also need to contact the employer check-in service, again, depending on the reason why you can't actually do that one way via the normal portal. Usually to do this in circumstances where there is confirmation of an application that's been made, but there's no determination, or there is an appeal of the individual, or an administrative review of a decision pending with UKVI. It will only establish a statutory excuse if you're issued with a positive verification notice, and when you log in, it's usually like a big green tick that will say yes, this person has got the right to work in the UK, confirming that the named person is allowed to carry out the work in question as well. So as I said, if you can't do an online check, find out the reason, and if it's not available to you, you move on to the manual check. So next slide.
Sorry, there seems to be a little bit of a problem. There we go. We've got it.
Okay, so there's this is what's known as a three-step check. You've possibly heard it many times before in terms of a manual-based right to work check. So step one is obtaining original documents from either list A or list B of the list of acceptable and appropriate documents. Step two is checking those documents, and you're checking that they are genuine, that they are original, and that they're unchanged, and they do actually belong to the person who has actually given them to you. In terms of actually checking those documents, what you need to also be looking for is that the dates for the applicant's right to work in the UK has not actually expired, that the photos are the same across all documents and they do look like the applicant who's presented themselves for work, that the dates of birth are the same across all the documents, that the applicant does have the permission to do the type of work that you're offering, including any limit on the number of hours that they can work. I'll point that out because sometimes you might have a migrant who is on a student visa, and actually the hours of work that they can conduct during term time and outside of term time will be different. So you just need to be aware of that as well. If two documents give different names, the applicant has supporting documents showing why they're different, such as a marriage certificate, for example, or a divorce decree. And also, again, I think one of the main ones was check that the expiry date hasn't actually gone. In terms of step three, in making a clear copy of a document, and as I said, I have seen some employers fall down at this particular stage. You need to ensure that there is a clear copy of the original documents which have been presented to you, and that includes copying both sides of a biometric residence permit. Sometimes I have seen ones where, you know, you've taken photocopy of the front page with the, you know, of the card, the pink card, you've got the image, you've got all the details, but actually you need to turn it over and also take a photocopy of the back of that as well. And also initial documents on the date that you actually completed the check. And just a word of warning, simply writing a date on the copy itself will not accurately record that you conducted that appropriate right to work check on that date. So you just need to make sure that you are recording it in the appropriate format as well. Okay, can we move on to the next slide?
There we go.
I think the computer knows we're nearly heading into the weekend.
It seems I have to press it 4 times for it to move on, which is it's how I feel today, probably. So, okay, for the next few slides, we're just going to cover some tricky areas that you might come across. You may have already come across, or you might come across the real life examples of questions that clients have had for me since June 2021. So I'll just run through them, and hopefully it might answer some of the questions that you have. So what if an EU citizen doesn't have EU settlement scheme leave? So I'm just getting a little bit of feedback. I don't know if everyone else is getting that, but apologies if you are. So in this instance, for example, a job applicant comes to you and they're a really great candidate, but they don't have the right documents to show that they have EU settlement status leave or EUSS leave. Now the guidance is very clear. You cannot recruit, so this is after the 30th of June 2021, an EU citizen who doesn't have the right to work. So if they don't have EUSS leave, or they don't have another way of showing you that they've got the legal right to live and work in the UK, then you cannot give them the job. All you can do, in what the guidance says, is you can signpost them to make an application. So you could suggest that they make a late application to the EU settlement scheme, but nothing more than that. Now, I would say be careful with this, because although they don't have EUSS leave, they may have another lawful basis to live and work in the UK. So, for example, they might have an outstanding application for the EU settlement scheme. So as Rox said earlier, they just haven't had a determination on that yet. And we'll talk about what to do in that situation shortly. And they may have a frontier worker permit, which again, we're going to look at in a bit more detail. They may have indefinite leave to remain or indefinite leave to enter, which would be a separate right, separate to the EU settlement scheme. And they would be able to evidence that. Or they may already be a sponsored worker working for a sponsor license holder organisation in the UK, and they may want to transfer the sponsorship over to you if you're a sponsor license holder, or if you're thinking of getting one. So there are lots of different options, but the guidance is very clear. If they don't have the EU settlement scheme leave, or they don't have another lawful basis to be in the UK, you can't employ them. It's not like the position we were in 12 months ago, where all they needed was a passport or a national ID card. So that's that tricky area. Next up, do you need to carry out retrospective checks on existing staff? And I think this question's been asked in the chat box. I think it was Emma. So I'll go through it and hopefully it will answer your question. So the guidance confirms that there is no requirement to conduct retrospective right to work checks on EU citizens who started employment before the 1st of July 2021. And it was a very grey area at the time, and leading up to the 1st of July, we were very uncertain about what the border agency's position would be on that, but they have since come out and made it clear that there are no retrospective checks required. The one caveat is if somebody has time-limited leave, you may need to do repeat checks on them, or you would need to do repeat checks on them if they have time-limited leave. But otherwise, there's no need to go back through your workforce and start doing retrospective checks. You have a statutory excuse if your right to work checks were carried out in accordance with the guidance that applied at that time. So if prior to the 1st of July, an EU worker wanted a job, you checked their passport or the national ID card and it was compliant, then you gave them the job, that's fine. You've complied with the rules at that time and you have your statutory excuse. Now, some clients have asked me, well, what if we need to do retrospective checks? So, for example, if you've got concerns that checks weren't carried out correctly at that time and pursuant to the rules in place at that time, or maybe just no checks were carried out at all, it's been overlooked with all the madness of COVID and the pandemic. How do we do that? Well, yes, in that situation, you should do a retrospective check if you have real concerns that the check wasn't done properly or wasn't done at all, but you need to be very careful in how you carry out those checks. And I would suggest that you take advice on doing that, because there's a significant risk that you could do so in a discriminatory manner if, for example, you are pick and choosing certain people or certain groups to have a retrospective check carried out upon. So if you're thinking of doing the workforce as a whole, that's probably going to be okay. But the minute you start to select groups or individuals, there's a significant risk of discrimination there. But otherwise, if you don't need to do the retrospective checks, I would very much advocate that you don't do them. Okay, what if an applicant has a pending settlement scheme application? And I'm sure you'll have seen in the news, there was a huge backlog with settlement scheme applications. I think there's something like 6.2 million applications made. And at one point, there was 700,000 outstanding applications. I think the numbers have dropped since. We had the quarterly report and it dropped down to about 400,000. So we're probably below that figure now, but that's still quite a number of people who haven't had a decision on their EU settlement scheme application. So what do you do in that situation if you've got a job applicant who says, well, I've made my application, but I haven't yet heard back? And the guidance says EU citizens and their family members who have made an application under the settlement scheme up to and including 30th of June 2021 and who are waiting on a decision can maintain their right to work until their application is finally determined. So you need to give them the benefit of the doubt with that. And the process that you need to go through is, as I said, from the 1st of July 2021, applicants will be issued with a digital certificate of application. So what you need to do, if they've digitally submitted their application, then they should be able to give you a digital certificate of application and then carry out an employer checking service to get your positive verification number, which will give you a statutory excuse for 6 months. Some people may have made a paper application, and the backlog for that is much more significant, as you'd expect. So they would most likely have a paper copy of the certificate of application. Now, if they can't provide that with you, what I would suggest is you still contact the employer checking service, find out what the position is there first, and then push to get that paper copy of the certificate of application as well. But just bear in mind that with paper applications, it can take even longer to get the evidence. And the guidance is very clear that you must provide applicants with every opportunity if they have a pending settlement scheme application, because what the border agency don't want is for somebody who has an in-time valid application to have their right to work either curtailed or for them not to be offered a job because they haven't been able to provide the paperwork. So try as best you can to accommodate them with that process. Okay, next tricky area. What if an existing employee tells you that they haven't applied for the EU settlement scheme in time? So earlier we looked at job applicants who didn't have EUSS leave, and the position is very different for them. You cannot employ them, you can only signpost them to make an application. But in this situation, what if you've got somebody who's worked for you for 2 or 3 years, they come to you, and perhaps you work in HR, they come to you in a panic, I realise now that I should have made this application, but I haven't done it. What can I do? Am I going to be sacked? You can hear the story unfolding. So this is for those people who are currently working for you, not for job applicants. And the government have set up some transitional measures so that these people keep their jobs, that they're not dismissed, and to really give them the benefit of the doubt because they are part of our existing workforce. So just to look at the transitional measures on the next slide, there's a process that you need to go through. So firstly, you need to say to your employee that they must make an application for the EU settlement scheme within 28 days. That's the first step. The second step is that the employee must then provide you with a certificate of application or an email receipt for their application. So essentially evidence that they've done what you've asked them to do. And then you need to go onto the employer checking service and check that they've made that application. And you should be given, if they have made it, you should be given a positive verification number, which gives you a statutory excuse for a 6-month period to enable UKVI to deal with the application and for the individual to get their outcome, which will hopefully be positive, given that they are being quite flexible with their approach to the settlement scheme. Now, if for whatever reason the employee doesn't make that application within 28 days, or they make the application but it's unsuccessful, then the guidance says that the employer must dismiss the employee in that situation. As with any case like this, it's always fact dependent, and I would encourage you to take advice before doing that, because obviously the individual may have unfair dismissal rights, but also there's a risk of discrimination. So I would always urge you to take advice on that point, but that is what the guidance says if the individual doesn't then go on to make their application. Okay, I've had a few questions about Irish citizens and how they prove their right to work, and it's quite an easy one to answer this one, because way before we had the EU in existence, we had what's called the common travel area between Ireland and the rest of the UK, which means that Irish citizens can continue to have unrestricted access to work across the UK. So in terms of the Brexit process, that hasn't had an impact on this area. So as long as that individual can present you with their passport or a combination of documents, so birth certificate and an official document showing the national insurance number, going back to list A and list B just to check that they've got what you need them to have, then the situation hasn't changed and you can continue to employ them as normal. Okay. I said earlier I was just going to touch on frontier workers, and the main reason for that is because I am, I don't know if you're noticing it as well, but there do seem to be quite a lot of frontier workers working particularly in your sectors, so in the care sector, and they're a really valuable resource for a lot of organisations. So it's just to run through what a frontier worker is and how they would evidence their right to work in the UK. So a frontier worker is an EU citizen who is resident outside of the UK but economically active in the UK. So again, from speaking to my care sector clients, they may live in Poland and they have family or children in Poland, but they come to the UK, they maybe do 3 weeks of work as a care worker, and then they return to their home country maybe for a week, and they have a pattern of, as I say, being economically active in the UK but living elsewhere. And again, the government wanted to protect these individuals' rights, providing that they were doing this work and working in this way before the 31st of December 2021. So their rights are protected, but they will need a permit to show that. So from the 1st of July,
that's correct. Yeah, that's correct.
It's mandatory for a frontier worker to have a permit to enter the UK. In terms of the work that they're doing, then they should be spending less than 180 days in a 12-month period working within the UK to qualify for frontier worker. And what I've typically found is that individuals either qualify for the EU settlement scheme or they don't quite make it, so then they've applied for a frontier worker permit. And the one thing about frontier worker permits, if you do have staff who are concerned about it, it can be extended indefinitely. So it's a 5-year permit, but you can keep extending it so long as you meet the requirements of the scheme. But it isn't a route to settlement, and that's why a lot of individuals chose, if they were eligible, they chose the EU settlement scheme because that is a route to settlement, whereas frontier workers, they can't settle in the UK on the back of that. If they decide to eventually. But in terms of document checking, generally these individuals will have a permit now if they're here doing this work in the UK. There are special rules in place. I'm not going to go into details, but there are special rules in place for those people who can't present the permit. So probably want to look into more if the situation arises. Okay, and then Roxanne is going to have a look at COVID adjusted checks for us.
Okay, yeah, so can we still do adjusted COVID checks? Angela has touched on it earlier. Yes, we can. The end date for temporary adjusted checks has now been deferred to the 5th of April of next year, 2022. As you know, from being in the pandemic, we've all been working remotely. It made it very difficult for us to be able to conduct the right to work checks in the usual manner. So the Home Office has said that they will extend those dates to next year, whilst the UK still continues to work through its response to the COVID-19 pandemic. I believe the intention of the government is to introduce a new digital solution to include many who are unable to use the Home Office online checking service, including UK and Irish citizens at some point in the future. And it will enable checks to continue to be conducted remotely, but with enhanced security. So for the time being, we can still do adjusted COVID checks until April, but I believe if you can conduct a manual right to work check, then do that as well. In terms of the temporary measures which did come in as a result of the pandemic, so those were introduced 30th of March last year, 2020. That meant that checks can currently be carried out over video calls. Job applicants and existing workers can actually send in scanned documents or a photo of documents for checks using email or a mobile app, rather than actually sending in their original documents. The employers, you should use the Home Office employee checking service if a prospective or existing employee can't provide any of the accepted documents as discussed earlier. So in terms of someone presenting themselves to you, what you should be doing in terms of these temporary COVID adjusted checks, you should firstly ask the worker to submit the scanned copy or a photo of their original documents via email or using that mobile app. Arrange a video call with the worker, and what you do, you actually ask them to hold up the original document to the camera and just check them against the digital copy of the documents which they've already sent through to you. Again, you'll just need to record the date that you made the check and mark it as an adjusted check undertaken on X date due to COVID-19. So as you can see, that goes beyond just recording the date that you've actually conducted that check. You need to say, if you are doing an adjusted check, state that fact. If the worker has a current biometric resident permit or biometric residence card, or has been granted status under the EU settlement scheme or the points-based immigration system, you can also use the online right to work checking service while doing the video call with the individual. And the applicant, however, must give you that permission to view their details. And as I discussed earlier, you can't actually force someone to do that. In terms of retrospective checks, Angela has touched upon it already. Again, you don't need to carry out retrospective checks on those who had a COVID adjusted check between the 30th of March 2020, taking it now forward to the 5th of April next year. This will reflect the length of time that the adjusted checks have actually been in place by the government, and also supports businesses during this difficult time. You will maintain the defence against civil penalty if the check that you have undertaken during this period was actually done in the prescribed manner or is set out in the COVID adjusted checks guidance. Those are available again online. Can we go to the next slide? Okay. Okay, how do you comply with obligations to actually prevent illegal working? So again, it's everything that we have been discussing on this session. You know, it is making sure that you are carrying out those right to work checks prior to employment commencing. I have seen cases where people have been allowed to start work, and then the right to work checks are then being conducted after they've already worked a day for us. You wouldn't establish a statutory excuse if it was found that that person was actually illegally working in the UK. So you just need to make sure that you are getting the infrastructure in place to conduct those checks before employment actually begins. Just in terms of that particular point of conducting checks prior to employment beginning, a word of warning, we don't like to make it easy for you, is don't conduct them too far in advance because immigration status might actually change. So it is a balancing act, but you just need to make sure that they are done prior to them starting. Again, you need to put in the repeat checks as required if someone has got a time limited right to work, and the government on their list A or B of acceptable documents, they do have a handy sort of check box where, depending on the documents which have been provided to you, it will indicate when you need to carry out those follow-up checks. And what I would recommend, just make sure you have appropriate personnel HR records which are recording dates of when right to work checks actually expire, so that you are chasing the individual prior to expiration if they are intending to renew any applications, just so you've got those in your diary as well. Again, keep records of all checks carried out. Obviously, this is good practice. It's in part of the 3-step checking for online and manual checks, and also assist if, for example, if you are say a sponsor that you are visited and audited by the Home Office at some point down the line as well, that actually all your documents are in apple pie order. Do not employ anyone that you know or you have reasonable cause to believe is an illegal worker. This is a huge no-no, and actually this amounts to a criminal offence where you could be imprisoned and face an unlimited fine, so nobody wants that. And also comply with your sponsor management system obligations, again if you are a registered sponsor. Can we have the next slide? Okay, so this is sort of the penalties, really, as I was mentioning earlier, as to what can be imposed upon you if you are found to be employing an illegal worker. It starts off as a civil offence, 20,000. So the Home Office will slap you with a £20,000 civil fine straight away for each illegal worker that they find in your organisation. So you can see how costly this can be for a business, and potentially put business under if they are found to be employing a number of illegal workers in their operations. This could actually go to an unlimited fine if you are knowingly, or you have reasonable cause to believe that you may be employing an illegal worker. So the cap actually comes off on that fine. That can be unlimited, and as I said, that can be a criminal offence. The penalties, as I said, are hefty. In those serious cases, criminal conviction carrying a prison sentence, and it can be up to 5 years. This used to be up to 2 years. However, that has been amended by the Immigration Act 2016, which has increased that penalty to 5 years. So really clamping down on this, and the government really showing the teeth, that this is a huge no-no. Also, they can instruct temporary closures of your business, and a compliance order issued by the court that can have devastating effects upon your business. If you are a registered sponsor, if you hold a sponsorship license, again, that might potentially be up for grabs back by the Home Office. You might lose that. So you won't be able to sponsor any further migrants, depending on what your operations are and where you rely upon your work talent. Again, that can be devastating for an organisation. And seizure of earnings made as a result of illegal working as well, that can also be imposed. So the Home Office do have the teeth here to really shut down a business in respect of this. So taking these obligations seriously, it's the first step, and just making sure that you are conducting those checks appropriately and in accordance with the government guidance to avoid that. What I would say, and the Home Office do like to do this, and they've obviously been quite busy with the pandemic, and obviously the points-based system has changed as of the start of this year, but they sometimes conduct spot checks on organisations who hold sponsorship licenses, just to check that all their documents are in place and that you are actually complying with your sponsor duties. If you ever get a visit from the Home Office, for example, if they are going to issue with a civil penalty, what I would say is comply with what they are asking you to do. Sometimes, you might have a junior worker who receives someone turning up at the door saying they're from the Home Office and that they want to see all your books. And that person might say, well, you're going to have to wait until my boss gets back. Not a good look, not a good step. What I would say, if they do turn up, invite them in, get your books out, go through it with them. If you are seen to be helpful and complying with everything that they're asking you for and being cooperative, you can work down a civil penalty as well. So it starts off from the 20 and it can reduce, and potentially, if you've got a great lawyer in the background as well, you might potentially get that down to 0. So if you are in that situation, take advice, contact either myself or Angela, and we can assist further on that.
Thanks, Roxanne. Okay. And just as a final section, we're going to look at the skilled worker sponsor license. As I said, some of you may already be license holders. It may be something that you've looked at and realised it isn't for you, or you may be weighing up the options as to whether it can help your organisation. I know in terms of the care sector at the moment, I've heard the phrase recruitment crisis in terms of actually getting people to do the job. I'm based up in the Lake District, and it's a similar story with hospitality, with the pubs and restaurants in my area, that they're having to close their doors because they don't have the staff to do the job. So it may be that a sponsor license can help you in part with that, and we'll look at the options and see what is available. So again, just to summarise the current position and how we've ended up at this point. So as we've already talked about, ending a free movement, we've got the EU settlement scheme now. But in the process of that, we have a new points-based system, a new immigration points-based system. And at the time, Boris said that it would be a revolutionary new system and it would be akin to an Australian model of points-based system. In matter of fact, it's actually quite similar to the system that we already had in place for non-EU citizens already, but the key difference and the reason why it's hitting us quite hard as businesses in the UK is because under this new system, EU and non-EU nationals are treated in exactly the same way. So in terms of eligibility under the scheme, it doesn't matter whether you're coming from America, China, or Spain or Portugal, it's the same rules that apply. And in terms of how the new system works, so as I've said, it's a points-based system, and there are different tiers to it. I'm not going to go into a huge amount of detail because a lot of the tiers won't be relevant and won't help with the problems that you're facing. But suffice to say, it's for skilled workers and above. And I don't make the decisions about whether or not care workers are skilled or not, but in terms of the way the government have structured it, it's definitely aimed at those people who are in higher paid roles and what they deem to be higher skilled workers. So, for example, I'm sure you're already aware that care workers aren't currently eligible for the what was the tier 2, which is the skilled worker element of the points-based system, but senior care workers are and are in fact on the shortage occupation list now. So, as I said, it's not going to help with those people who aren't deemed to have a sufficient level of skill or salary, but it will help with managerial level roles, with senior care workers and above, really. In terms of salaries and skill levels, we're generally talking about RQF level 3, which is broadly A-level equivalent to be eligible to come in under this system. We're generally talking about a salary of above £25,600, but there are exceptions to that. And one of the exceptions is if the job is on the shortage occupation list, as senior care workers are, in which case you can pay as low as £20,480, but it does depend on the specifics of that particular job role. And in terms of the sponsor license itself, so I've got lots of clients who are applying for these at the moment, and some of them have a shortage of roles at present. Other clients are just getting them in place, have them ready, so that they've got that global recruitment potential. So they're not limited to the UK labour force, but if the right person comes along from wherever they are in the world, they are ready straight away to recruit them. And we'll talk about in due course about the timescales for getting a sponsor license, and that's why some clients are choosing to get them now. Okay, so very briefly again, just to talk you through the process of becoming a sponsor license holder. As I said, don't go into it with your eyes closed. Make sure that it achieves what you want it to achieve. So it's not going to help you recruit people who are earning minimum wage, but it is going to help with the higher paid and deemed to be higher skilled workers. So check that it's going to work for you. It's then an online application form and provision of necessary supporting documents, which you need to submit to the border agency. And make that sound like a very straightforward process. It's actually quite onerous. The online application form is notoriously difficult. The software is very old, and the list of supporting documents that you need to provide is very stringent, and you need to make sure you get exactly what the border agency are looking for. So have a think about it. Is it, if it is worth the investment and it is worth the time to have that global reach in terms of recruitment, then you know what you're doing in terms of the process. You also need to ensure that your organisation can manage its licence. So this is point 2 on the slides here. So you need to ensure that you can prove to the border agency that you can have responsibility for these sponsored workers. So if you're going to bring these sponsored workers into the UK to work for your organisation, are you taking care of them? Are you reporting to the border agency certain changes to their employment if they don't show up on their first day of work? Are you keeping records to show exactly what these sponsored workers are doing? So there are lots, I won't go into the details, but there are lots of different obligations and compliance points. And also you need to make sure that you have the right people in place to manage your sponsor license. So you will need to appoint an authorising officer, a key contact, and level 1 and level 2 users who essentially manage the sponsor system for your organisation. And then moving on to point 3, in terms of cost and timescales, it depends on the size of your organisation in terms of how much the application fee is to the border agency. The figures are on there. It's either £536 or £1,476, depending on the size. And as I said, if you're successful, the licence will be valid for 4 years. So that's why Some businesses are choosing to get one now so that they are ready whenever the right candidate comes along. And also importantly, I've said there, allow 8 to 12 weeks for the application to be processed. So that's just for the border agency's processing time. That's not the time that you need to spend in preparing your online application and getting together your supporting documents. If we were having this conversation a year ago, I'd say it would take 2 to 3 weeks generally, but everybody wants a sponsor license now. So it definitely is at the top end of that 8 to 12 weeks. I had one the other week that took 13 weeks. Just to, as I say, go in there with your eyes open. Now, there is a priority service. If you had the right candidate, you're desperate to get them into the country, you can pay for a priority service, and it's an extra £500. But the problem is, that's
out there on Friday.
It's really under-resourced, and it's very difficult to get a slot at the moment. It's potluck as to whether or not you are successful, names in a hat sort of situation. So you can't rely on the priority service, but it may work for you, if you make the submission for the applications at the time. And then once you've got your license, that means that you're then set up to sponsor employees to come in from other countries. And what the individual does, so if they're making their application from France, for example, they would go online, they would fill in their visa application form, they would go and get their biometrics, so their fingerprints taken at a local biometric centre. They would use a code that you give them through your sponsor license application. And as long as their job exactly matched the job that you said they were coming to do, the salary was correct, the job level role, and so on and so forth, they would then use all that information, and if their application is granted for a visa, they would enter the country as a skilled worker under your sponsor license. So that's pretty much how the process works from start to finish. As I've said, lots of businesses are getting them in place so that it does help with recruitment problems. As I've said, it won't help with all skill levels, but it will help with the senior, so the higher, medium and higher skilled workers within your organisations. And just to finish off here, I do get asked the question as to, if sponsorship isn't right for us, what are the other options available to us? And some of these we've already touched upon, but I'll just run through them as a closing piece, really. So the obvious and easiest way is through the EU settlement scheme. So if the individual has status, whether it's pre-settled or settled status, and I think we had a question about this, it doesn't matter as an employing organisation whether they have pre-settled or settled status, you can still employ them, but if they have pre-settled status, you will need to carry out a repeat check to see if they then get settled status, or if for whatever reason they've lost their status. So as I say, that's the single most straightforward way in which an individual can prove their right to work if they're an EU citizen. Again, the Frontier Worker Permit scheme, it won't work for everybody, but for those people who are living in another country but economically active in the UK, as long as they can hand you their permit as their right to work evidence, then you will be able to employ them. Just quickly, in terms of the business visitor route, again, this won't be this won't be right for everybody, but particularly if you're part of a global company and you have employees who want to come over to the UK to attend business meetings, to maybe attend meetings, give presentations, and maybe give some brief training, as long as they're not carrying out substantial work when they're here, and there are very strict rules on what they can and can't do, then it may be an option for them to come for a business visitor for up to a 6-month period. So that's something to explore to see if an individual might be eligible. And then finally, this is really a point that you've probably seen in the news about temporary seasonal workers. So you may well have seen that the government are allowing HGV drivers into the country, and poultry workers and those working in edible horticulture. So for example, to pick apples or asparagus or potatoes or whatever it might be. And you may be thinking, well, hang on a minute, why can't we do that in the care sector? Because we're in dire straits as well. We can't get care workers into the country. And it's a valid question. Now, as things stand, this is a route just for those specific 3 areas, so edible horticulture, poultry workers and HGV drivers. And the way it works is they're not sponsored by a particular employer or sponsor license holder. They are sponsored by an approved scheme operator, so essentially an agency, and then employers take the workers from that agency to carry out that specific work. Now, watch this space, because you never know the way in which the government may take this. If they deem that there's a sufficient crisis in the care sector or in the hospitality sector, they may well expand this route. It has been talked about, it has been lobbied, but at the moment, as things stand, it's not an option, as I say, unless you're in those specific 3 areas. Okay. And then I think we're just about, we're about 7 minutes left. It's just to say, if you do want to get in touch in the future, there's my email address on the slide, but also just to direct you to some useful links. So if you want to know more about the EU settlement scheme and how that works and how people may be eligible or what to do in terms of the detail of how they make applications, there's the employer toolkit, which is a very useful piece of information on the internet available to you. But also, if you want to explore more about the sponsor license application form, again, happy to take email inquiries just to get a bit more information about whether it might be right for you. But also, you can have a look at the application form and see, what work would be involved and what documents you would need to submit as part of that process. Okay, and that is a whistle-stop tour. Has anybody got any questions? I've got a little bit behind with the online chat, but if you do have any questions and you want to put those to us now, we'd be happy to take those.
I think there is a few in the chat box. I think Emma had put one previously about students and their hours. In terms of how do they verify the hours if they've got a migrant worker who's on a student visa. I think probably what I would say is, one, ask them, are they working for somebody else? Sort of similar to the steps that you take, to ensure that someone's not working over the permitted weekly hours for your normal workers. So I'd probably say number 1, ask them. But in terms of the work that you're offering, in any event, you'd need to obtain their academic diary to ensure, when is it that they're out of term time, because they can work more than the permitted hours outside of term time anyway. But I think in the first instance, just ask them, but just ensure that you're not offering more hours during term time than what they're supposed to be working.
That's great. Thanks, Roxanne. And I've seen a question there. Can I employ drivers? My agency deals with the provision of care only. Now, I think it's only specific drivers, and I can send the details afterwards. I think we may be doing some sort of FAQ document, but it's only drivers of certain goods. So I think, in answer to your question, no, I don't think you could use the temporary seasonal worker scheme to recruit drivers into those roles for the provision of care only. But it's worth having a look into, and as I say, I'll check it as well. But as I say, I'm pretty sure it's only for drivers of food goods and so on and so forth. Post the link. Oh, okay. Somebody's asking me a technical question, as if I can post the. I don't think I can actually. I can't post the. I can't seem to copy the web links onto the chat box, but I'm sure that we can get those to you afterwards. I can't see that being a problem, so I can send those out, and I think you're going to get the slides. Again, I'm probably over promising here, but I think you're going to get the slides, so we could make those live links in the PowerPoint presentation as well.
I think there's a question from Emma about, is there a guide to format for the retained records? There is very brief wording contained in the employer guide to conducting right to work checks as to what you should be recording on the copy documents when you're actually conducting those right to work checks. So it needs to go beyond just recording the actual date, and it'll be something along the lines of right to work check conducted by me, insert name, insert position on X date, see original documents viewed in the presence of the holder, something like that. In terms of the adjusted checks, there is specific wording, I think, on the guidance as well, which states adjusted right to work check conducted on X date due to COVID pandemic, and that's what you need to record on the copy document.
Thanks, Roxanne. I'm getting a little bit lost in the questions, but thank you for all thanking us, and I can't see any more questions, legal questions. I can see a few. Oh, people from Ireland. Sorry, I've missed that question. So yeah, in terms of evidence of right to work, whether they're from Northern Ireland or Republic of Ireland, they can travel freely to the UK. It's slightly different rules that apply, but it's the same principle, that you treat them as you would a British citizen, as long as they can evidence that they're from Ireland, whether it's Northern Ireland or Southern Ireland, I think was the specific wording of the question. But if I can't find the original question now, but if I've got that wrong, please feel free to email me and I'll clarify to you. I think we've got lots of questions about recordings and slides and things, Callie, but I'm pretty sure people will be getting things afterwards. Okay. I think that's everything, but as I say, if anybody has any direct questions, please let us know. It's been lovely to present to you this afternoon and to meet you all virtually, and I hope we get to work together at some point in the future. And thanks to you, Roxanne, for helping me today as well.
No problem.
Okay then, I think we'll sign off if that's okay. Thanks everyone.
Bye.
Bye.
Bye.